There are a lot of court cases out there that are very legitimate, but naturally for every 5 legitimate cases, there's probably 1 or 2 frivolous or ridiculous cases that are thrown in the mix that really just make things crazy. I did a short about Cold Stone Creamery getting sued by some lady because she was mad that there weren't actually any pistachios in the pistachio ice cream. I thought the lawsuit was just so ridiculous that I decided to go ahead and compile 10 of the craziest, most frivolous, and scam lawsuits of all time. And some of these things you guys are just gonna love. Let's hop right into it. These are all actually real headlines. So at number 10, we have Peta suing a photographer on behalf of a monkey. Peta ended up suing a photographer over selfie photos of a monkey back in 2015, claiming that the monkey had legal rights to the copyright of the photos. British nature photographer David Slater is perhaps best known for a collection of photographs of a macaque. The so-called monkey selfies irritated Peta to the point where they saw it fit to launch the lawsuit. The suit looked to, quote, allow Peta to administer all proceeds from the photos for the benefit of the monkey, which it identified as a 6-year-old Naruto and other crested macaques. The U.S. Copyright Office, however, stepped in and says that it'll only register copyrights for human works. It took 3 years until 2018 for an appeals court to rule against Peta, backing up that animals can't legally hold copyrights. Figure that. They were concerned that Peta was more worried about advancing its own interests rather than protecting the legal rights of monkeys. To me, I think I agree with the court. It looks like Peta was maybe just looking for a little bit of free publicity there. A lot of these wild things that they do might not be them actually trying to win the lawsuit, but trying to get their name in the headlines to gather more support. Moving on to number 9 at the list. A California man decided to sue Starbucks for putting too much ice in his drink. The class action lawsuit alleges that customers ordering iced beverages from the coffee giant got less liquid than advertised because of the space that the ice takes up. The judge pointed out that, quote, if children have figured out that including ice in a cold beverage decreases the amount of liquid they will receive, the court has no difficulty concluding that a reasonable consumer would not be deceived. Starbucks also chimed in on Twitter, reminding buyers that you can order with light ice if you want more drink or extra ice if you want it colder. They also said that if a customer is unhappy with their beverage, simply asking a barista will get them a new one. The lawsuit ended up being dismissed by a federal judge. For the next one, let's mix it up a little bit. The first 2 had been lost by the plaintiff, but this one, the plaintiff got a little bit luckier. Coming in at number 7, an Israeli woman sued a television station because it rained when they said that it wouldn't. Most of the time, weather people are pretty on point, but every once in a while, they don't get it right. Weather is an ever-evolving science, after all. Anyways, the woman from Tel Aviv decided that she needed $1,000 in compensation and chased after Channel 2 and forecaster Danny Roop in order to get it in small claims court. After trusting the forecast, the woman left home dressed lightly, but it turned out to be stormy on that day. She blamed the Weather Channel combined with the way that she dressed lightly for the weather she thought was coming for catching the flu. This made her miss 4 days of work and caused her to spend $38 on medicine. She says that she also suffered stress in the situation. She wasn't only seeking the financial side of things, but also wanted the weather forecaster to apologize as well. The TV station ended up settling the case out of court for the $1,000. She even received her apology. It seems like they probably thought that the $1,000 was cheaper than defending themselves in court, as this lawsuit would have almost certainly been thrown out. Hopefully, they didn't set up a bad precedent for themselves for everybody to sue them every time that they get the weather just a little bit wrong. If you thought number 7 was crazy, number 6 gets even worse. In 1998, a Florida man went into an adult nightclub and ended up leaving with a lawsuit after he claims that one of the dancers battered him with her, quote, crazy big end quote. The man wanted to head to court, claiming a whiplash injury after the dancer swung her chest, hitting him in the face during a bachelor party. The man's exact quote is that they were, quote, like 2 cement blocks, end quote. The woman whose stage name was Tawny Peaks actually ended up on People's Court TV show where a female bailiff had felt the implants, noting that they were, in fact, soft and not like cinder blocks at all, weighing about 2 pounds each. The court refused to award any damages. Peaks went on to try and sell the infamous implants after she had the size 69 HH situation removed and underwent reduction surgery in 1999 when she wanted to put the exotic life behind her and start a new life. An internet casino company actually bought the autographed implant for $16,766. This is such a weird society that we live in. I couldn't imagine actually showing up in court for something like that with a straight face, but I guess that some people have a different idea of what qualifies for a lawsuit than I do. In the next one, the guy has a little bit better of a case, but it's still pretty wild to think that somebody would sue for this. So let's move on to number 6. A man sued British Airways after he accidentally booked the wrong flight. The American dentist Edward Gamson was looking to brush up on his Spanish history, heading to the city of Granada, Spain for a vacation after a work conference. He was in for quite the shock when he got on the plane and the monitor in front of him said they were going in the opposite direction, landing him and his partner on the opposite side of the Atlantic Ocean in Grenada, a country in the Caribbean. A country that sounds the same as Grenada, Spain, but is spelled slightly different. This one's located in the Caribbean. After booking a 2-hour flight from London, it had to be quite the unwelcome surprise when the flight actually took 9 hours instead. After 7 different flights, he finally ended up where he wanted to be in the first place. British Airways refused to reimburse the $4,500 first-class ticket, so Gamson decided to sue for $34,000 in damages. The case ended up being dismissed. I guess that if he used a travel agent or something like that, there might be a case there, but at the end of the day, I feel like you're still responsible for making sure that you have the right ticket, and the court seemed to agree. Number 6 might have had a little bit of a point, but at number 5, I feel like we get into a situation that gets downright petty. In 2012, a Michigan woman opted to initiate a lawsuit hoping to gain compensation for the half tank of gas that was left inside of her repossessed car. In return for the gas, the lawsuit sought out $5 million. Yeah, really. LawyersandSettlements.com did the math and determined that with the car's fuel tank capacity and gas prices at the time, the gas was worth roughly $29. This was the beginning of a class action lawsuit that rode on the coattails of the idea that if a car is repossessed, all personal property inside of the vehicle has to be returned to the owner, and so should the gas, or at least the gasoline's fair market value. Her attorney argued that gasoline is just as valid to be returned as a jacket left in the back seat. The internet didn't give any closure to what happened in this case. Moving on from number 5 to number 4, we go from a case that I feel like is a little bit petty to a case that is downright ridiculous. Like, I can't say that I've ever heard of anything like this. In what might be the biggest waste of a court's time ever, a man attempted to sue himself. Apparently, Robert Lee Brock was an inmate at the Indian Creek Correctional Center in Chesapeake when he tried to sue himself for getting drunk and violating his own civil rights. In the suit, he looked to recover $5 million from himself. The catch, he wanted the state to pay for it all. Brock said that he got drunk and caused himself to violate his religious beliefs, leading to 23 years behind bars. If you're wondering what someone has to gain by suing themselves, the next line in the lawsuit clears it all up by relaying that he wanted the state to pay out on his behalf since he can't work and was a ward of the state. Don't worry, though, because Brock promised to pay it all back by court order when he ends up getting out of lockup. The lawsuit was dismissed as frivolous, but the judge gave the case credit for being, quote, an innovative approach to civil rights legislation. Some of these cases are incredibly frivolous, but at least people have something material to go off of. I mean, I guess that, like, the Starbucks one, for example, while most people would probably disagree with the person suing Starbucks for having ice in their drink, there's at least a little tiny thread of maybe something material that maybe 1 out of 1,000 people could see happening. But in this case, there's just absolutely nothing logical to go off of. It sounds like somebody just sat in jail for too long and just came up with ideas, hyped themselves up, and decided to go to court over it. And the next one, we have, I don't even know how to introduce this one. So I'm just going to read it, and you guys can be the judge of what you think of this lawsuit. A man once sued Michael Jordan for $416 million, all because Alan Heckard thought that the basketball legend looked a little bit too much like him. He also tried to sue Nike for the same amount, claiming that they're the ones who made Jordan a celebrity in the first place. Heckard, who honestly doesn't even look all that much like Jordan to me and is half of a foot shorter, said that he couldn't do things like attend religious services, ride public transport, or play sports in public parks without being mistaken for one of the greatest basketball players to ever exist. Even if we're taking this guy's word for it, it probably didn't help that Heckard was also bald, and news reports said that he wore the same earring and Air Jordan sneakers as Michael himself. He's definitely not helping his own case there. He told reporters that he's consistently mistaken for Michael and, quote, even when I go to the gym, I'm being accused of playing ball like him, end quote. He claimed emotional pain and suffering as the basis of the lawsuit. He eventually ended up dropping the suit himself. Something like this feels to me like maybe somebody was trying to get a little bit of publicity. He kind of had me going a little bit until he said that he goes to the courts and people accuse him of playing basketball like Michael Jordan. That's where it kind of starts to feel a little bit like a joke or some sort of publicity stunt or something like that. Moving on to number 2, we check in with another wild situation. This time somebody's suing a beer company, and it's definitely not for any reason that you're probably guessing. So let's go ahead and just jump right into number 2. A man sued a beer company because the lifestyle that he saw in their commercials didn't happen when he bought their product. Commercials have a way of making life look pretty amazing after simply purchasing a product. As we all know, real life usually doesn't work out this way, but apparently Richard Overton wasn't too happy with Anheuser-Busch back in 1991 when the purchase of their beer didn't bring him, quote, a scenic tropical setting, beautiful women and men engaged in endless and unrestricted merriment. The suit was eventually dismissed, but Overton was cited as recently as 2007, still fighting the good fight, claiming that the whole idea came because he was upset that his kids were being drawn into the advertising. That simply wasn't true. He wasn't too happy that the story originally painted him as the guy who thought that beer would help him find pretty girls, but to me, it seems like this story doesn't really hold weight. And at this point, you're probably thinking, how can the lawsuits get more frivolous, scammy, or ridiculous than that? Right now, I'm about to tell you, but right before we get to number 1, let's do a little bit of a consolation story here, and one that you're probably surprised doesn't end up on this list if you're familiar with it. Let's talk about a lawsuit that people probably will be confused isn't on here, the McDonald's Coffee lawsuit. Everybody knows about this infamous story. And if you don't, basically, a lady got coffee from the drive-thru at McDonald's. She spilled it on her lap and ended up trying to sue them. When researching the story, though, it turns out that this lawsuit wasn't all that frivolous or crazy at all. Instead, the woman who spilled the coffee ended up winning because the coffee was served at temperatures that are probably a lot hotter than anything that should be served like this. She was injured from the coffee, and she got third-degree burns by spilling it on herself, which required surgeries and skin grafts. She won $640,000 in that suit. So if that can't be number 1, what is? And if you didn't think of this one, when I tell you what it is, you're going to be like, oh my God, how did I not remember that? And I kind of had that reaction when I stumbled upon this story because I forgot that this was even a thing, but it was such a big thing back in 2005 that everybody alive back then had to have heard about this. If you were around in 2005, there's a very good chance that you heard about the woman who allegedly found a finger in her Wendy's chili. Back in 2005, Anna Ayala claimed to get an unwelcome 1.5 inch surprise in her chili, a severed finger. Of course, something like this would be the beginning of a very massive and very lucrative lawsuit if it were actually a real story. The first sign that things were amiss, though, were lab tests that said that the finger wasn't consistent with meat that had been cooked for 3 hours at 170 degrees, Wendy's policy for this dish. Eventually, the real story was uncovered. The story went that a co-worker of the woman's husband lost the finger while at work, and she decided to buy it off of him for $100. What kind of weird transaction is that? Anyway, she tossed the finger into the chili, and they offered the coworker $250,000 when everything panned out if he would keep quiet about their plan. When push came to shove, Ayala and her husband, Jamie Placienda, pleaded guilty to conspiracy to file a false insurance claim and attempted grand theft with damages exceeding $2.5 million. She was sentenced to 9 years and he got 12. It looks like they're both out of prison at this point and posting on Instagram, but will forever be remembered for one of the most viral scam lawsuits in history. If you watch this whole video, thank you guys very much for tuning in to my first ever video on the That's Actually News channel. I hope to bring you a lot more videos like this where we dive into some of the craziest stories that the world has ever heard and dissect them. I feel like from the cases that I've read, this list did a good job of encompassing the 10 craziest, scammiest, and most frivolous lawsuits to ever exist. But but if you can think of any that belong on this list, be sure to leave it in the comments below. Thanks, guys, for watching. I appreciate you all. This has been That's Actually News. Hopefully, I catch you guys next time. Thanks for watching. Later, guys.